Good morning. Good morning. I'm Darren Foote. I'm glad to welcome you to this edition of Learn to Restore's Flood Files. And I'm really excited to welcome Yasmin Whitmer to be with us today. Known Yasmin for several years. We've worked together on a few projects. I've come to really respect her as an individual, as well as her as a resource for restoration contractors. She's been, and she'll hopefully go a little bit more into that, but she's been involved in this area of law specifically for what we do as restorers for many, many years. So I'm just going to give a quick intro here. Yasmin Whitmer, sorry about that, Yasmin.
Okay.
Yasmin Whitmer, a practicing attorney and founder of Whitman Law and needtolien.com, a very important resource. Specialized in representing restoration companies in Michigan. She noticed a common challenge among contractors, which is the high cost of legal representation for filing construction liens and a lack of immediate access to attorneys. And I feel that pain personally. I know what you're talking about. Recognizing the need for a more accessible solution, she launched needtolien.com, a user-friendly platform that simplifies the lien filing process. With needtolien.com, contractors can input project details easily, leaving the complexities of lien filing to Yasmin's team. This innovative approach empowers contractors to focus on delivering quality services while ensuring they get paid promptly. You can contact her directly, and her information will come up later. But Yasmin at Whitmer at whitmerlaw.com, or, and again, this will come up later, but 248-671-4482. So with that, again, Yasmin, I know you've got a busy schedule. Thank you so much for taking the time to join us today, and I will turn it over to you.
Sure. Well, thank you, Darren, and good morning or good afternoon, everybody. I really appreciate everyone signing up for this class because I believe it is a very important tool, construction liens, that you guys can have literally in your toolbox to be able to collect on the files that you work on the jobs that you work on. But before I get started on all fun legal aspect of what a construction lien is, let me give you a little bit of a background about myself. I appreciate everything Darren said. So I started in the restoration industry back in 2016. I was an attorney for the largest restoration company in the world. And out of there, because of my experience there, I ventured off and opened my own law firm in Michigan. And all I do exclusively is represent property restoration contractors in all aspects of their business, from litigation to collections to M&A to contracts, whatever it may be, risk analysis. That's what my primary focus within our firm is. As a result of these many years in the restoration industry, I filed a lot of liens, and I noticed that really you don't always need an attorney to do it. It's nice to have access to one, but a lot of contractors, especially if you're starting off or you're not making millions and millions of dollars yet, you don't want to spend your funds on an attorney. There's got to be an easier way to do it, which led me to establish needtolien.com, which is a nationwide software that allows you to file your construction liens, your preliminary notices, notice of intent to lien, discharge of lien, and notice of foreclosure across the country in all 50 states. So it's more so a resource that I thought that contractors need, and I created it, and I'm really looking forward to presenting on the aspect of construction liens. And if you guys have questions after the seminar, please feel free to reach out to me and we can discuss further. But a disclaimer that I always have to do is this is not legal advice. You cannot take it and run with it and start practicing as if an attorney told you what to do and it's all binding within your state. So please keep that disclaimer in mind. And I'm licensed in Michigan, so you guys are from all across the country. Please discuss it with a local attorney as well.
Yasmin, just to interject, I should have said this before. For questions, if you've got something that comes up during the meeting, we'll try and get to those as well. On this webinar, we will be using the Q&A feature, not the chat feature. So if you have a question, just pop it in the Q&A, and we'll take a look at it and get to it as soon as we can. Thanks, Yasmin.
Yeah, and I apologize. I'm a little slower on my slides. As I talk, I forget to click next. So let's get started. Let's talk about what is a construction lien. So a construction lien is a legal claim against a property that you, as a contractor, a prime contractor, as a general contractor, a subcontractor or supplier or material man, can file against the title of a private, a homeowner basically, or a commercial property. Note, you cannot file a lien on public jobs. So public jobs, anything you do for the government, you cannot lien on. So there is a distinction there. But why is a lien so important? That's because when you guys are doing work and you're investing and basically you are financing the job until you get paid out 60, 90 days out from completion from the insurance carrier, your money is not secured. You are working, you're basically have a line of credit for every job from your own pocket and is unsecured. So the lien, when you file that, it goes against the title chain of the company, of the property, excuse me. And because it goes and files against the title change, your debt is now secured. What that means is in the event of bankruptcy, you got some more protection. In the event of the homeowner or property owner wanting to refinance, they got to pay you off first. They want to sell their property, they got to pay you off first. And it just sits there as a cloud under title. So for commercial properties, the liens are absolutely amazing because no commercial property owner wants a lien on their property. You get paid so quickly, especially on commercial jobs, if you file the lien. Now, a caveat to all of this is I want you guys to navigate through that customer client relationships you have. So if you have a national contract with CBRE, don't go leaning their properties. Find a way to resolve that. But if you have but if it's a multi-million-dollar CBRE account, have that conversation with a property management CBRE or whoever it may be, right? And be like, I gotta lien it to secure my interest. So keep that in mind as a caveat. I'm not saying lien everything. You don't want to burn bridges with your customers, but you also have to keep your best interest in mind as well. So let's go through a little bit of terminology. Terminology is important as you guys navigate through filing your construction liens. You can, and I understand you may do it in-house, you may have an attorney, you may use the software such as Need to Lien or whatever it may be, but it's good to understand the terminology that you guys are utilizing. So a claimant, a lien claimant, that is you. That is the person who files the lien. That can be, so that is the entity name. And that is your address, right? It's the information about you that is filing the lien. You're the lien claimant. Property owner is the individual or entity that owns the property. The tenant or lessee is the individual or entity that is leasing the property. So here's a little distinction. When you file a construction lien, you need to list the property owner. So going back to my property management example, typically the property management is the one who signs a contract with you, but they're not the property owner. So when you are creating this lien document, you got to make sure that you know who the property owner is. And then you list the tenant, the lessee, the property management as an additional entity or additional name on the lien itself. Okay, so make sure you are doing your research and writing down the correct property owner. Lien deadline. Every single state, all 50 states have their own lien deadlines. The majority are about 90 days. I'll go through some samples in a couple of slides down, but 90 days is a very standard term. Some are 120, some are 180, some are short, some are about a year. But you got to know what that deadline is for your state, because I call it the lien clock, right? Deadline clock. Whatever that clock is, whatever those days are that allows you to file the lien, you need to implement them as part of your collection process. Now, I'm not going to have enough time to go through that, how you can navigate the lien within your collection process, but I will touch base on it. But if you want to talk to me about it after the call, I will happily do so and walk you through that. And then perfecting the lien or so perfecting the lien basically is enforcing the lien. What that means is you file the lien and every lien has a deadline to perfect. So for example, in Michigan, we have 90 days to file our lien, but we have 1 year to foreclose on it, to perfect the lien. So if you don't foreclose or perfect your lien within the 1 year after filing, your lien automatically becomes invalid and unenforceable. So if you have a lien out there, you got to make a decision. Either you're just going to let it go or you're going to hire an attorney to foreclose on it or perfect on your lien.
Yasmin, can I ask you a quick question on that? Just to clarify on number 3, can a tenant or lessee, can their actions encumber the, I don't know if that's the right word, but if a tenant hires you to do something on a property at someone's home, they're a renter and they hire you and then the bill doesn't get paid, can you still lien the property if the property owner was not aware of the contract?
Absolutely. So the lien is established based on the work you do on the structure of the real property. So contents, you can't lien on contents. You cannot lien for cleaning the contents. You cannot lien for manipulating the content. But if a tenant hires you because they had a flood in the basement and you do the mitigation work and you do flood cuts and repair and put it back, you can lien the property even though the property owner didn't even know that loss existed, because at the end of the day, you are making the property owner whole by impairing the property to its pre-loss condition. So just because a tenant signs up or a lessee signs, you still have your lien rights. Your lien rights are tied to the work you do to the property.
Thank you.
Yeah. Okay. So there are some ancillary documents I know I named them briefly in my intro, but I think it's important for you guys to know them as well because it plays a role on how effective your construction lien is once you decide to file it. So the notice of furnishing or preliminary notice, they're the same thing, they're just called different in different states. Basically, what this notice is, you put everybody on notice that, hey, I am Yasmin Restoration Company. I've been hired on this job and I'm giving you property notice that I'm here and I'm going to do the work. Should you not pay me, I'm going to file a lien. It's just a very friendly legal notice. There's nothing bad about it. In the majority of states, if you're a general contractor, you don't need to send this, or if you're a prime contractor, you don't need to send this. But the best practice here that if you're ever a subcontractor, send this notice of furnishing or preliminary notice out. Because once you do this in a lot of the states that require you to have this document, it will affect if you will be able to file the lien later on, because you have to put people on notice that you've been hired. Notice of intent to lien. So there's very few states that require you to send a notice of intent to lien prior to filing your lien. But what you can do with this is include it as part of your collection process. So what I mean with that is your collection process starts from the date you close, you complete the work, right? That's when your collection starts. Then you close the job, you send all your documents to the adjuster or the homeowner or whoever your client is. And from there, let's use 90 days in Michigan. You have 90 days from today to go ahead and get paid on it or file your lien. So this notice of intent to lien, if you are 45 days out or even you send your second demand letter, in my opinion, the notice of intent needs to go out with your second demand letter for payment, because if a property owner is going to ignore your threat that, hey, Darren, I'm going to lien your house. You didn't pay me. And if Darren is going to ignore you, then you know that's a red flag, high risk customer. You need to lien that property. A lot of times you're going to get like maybe gossip that they're going to sell their house. You want to lien the property, but this notice of intent to lien should always be as part of your collection about your second demand letter that goes out, just so you get a feel for the customer and where they are and how risky they are of not paying you. The construction lien, I know I've touched on this quite a bit, but this is the document that secures your debt against the real property. This is your bread and butter. This is what's going to protect you. And this is what's going to give you the most amount of leverage when you're collecting on files. Again, commercial properties do not want to lien because they have mortgages under property, they have secured interest, they have investors, they have whatever on their property that they don't want this to cloud their title, and then they're in default of whatever other agreements they have out there. So, and they don't want you to foreclose on it. They will pay you. Almost immediately, you're going to get paid because you're going to start a dialogue with them and you are going to settle it out or whatever it is, however you guys want to handle the claim. But for commercial is fantastic. For all homeowners, for most part, you're going to get paid and settle the claim out. And there's going to be the ones that you just got to follow through with the foreclosure. Discharge of lien. So this is when you've already filed the lien and now you just got to take it off the title chain because you've paid, you got settled out, the court made you do it, whatever it may be, but you no longer need the lien. You just have to dismiss it. You have to file this case, you have to file this discharge of lien so that when someone pulls up the chain of title, they can see that you filed the lien and then you later discharged it. Notice of intent to foreclose. So remember, every lien that you file, you get a certain period of time to foreclose on it, to perfect on it. This is where this comes in. That says, hey, Darren, you didn't pay me. I have this lien. I'm going to foreclose on your property within 30 days, for example, if you decide not to pay me. Again, is a good threat to have. Some states require is mandatory to send it out before you file foreclosure. But it's another tool you have to open up that dialogue with the customer who hasn't paid you before you hire an attorney and go through the expense of foreclosure. Foreclosure, is a lawsuit. You bring in court against a property owner. You also have to include other secured interests that are listed on the title chain of the property. It's expensive because you will need an attorney. And it's going to be a back and forth that you go, and it's a lawsuit, right? No one wants to be in a lawsuit. So if you can be very proactive ahead of time to not get to this point, I highly recommend that. But foreclosure is the very last resort you have in order to get paid on a lien you have. And I have foreclosed. I mean, I haven't foreclosed on the property, but I file foreclosures often, and I settle those out almost always because no one wants their house taken away. Nobody. And it's another reason for you to get their attention. Be like, okay, you ignore me for the past however many months. Now I'm going to be really serious and start this process.
Yasmin, jumping back just a little bit, we've got a question in the Q&A. Do you have to discharge a preliminary lien notice?
No. So aside from the construction lien and the discharge of the lien, the other documents do not get filed with the registry of deeds or the court wherever your state requires you to file them. So the preliminary notice does not go on the chain of title. Send it via certified mail so you have actual receipt or documentation that says I sent this to the property owner on this date and it arrived. So certified mail everything. So if that answers the question, let me know. But just the discharge and the construction lien are the only two things that go against the title. The rest are mailed in.
This is just a side note from my experience, but in Nevada, where I am, as I recall, subcontractor has to pre-lien because even if a contractor is paid in full by the homeowner, the subcontractor can still lien the house and take it if they don't get paid.
Right.
So one thing we learned we had to do was help our homeowner understand when you get a notice of pre-lien, it doesn't mean we're not paying our bills. It doesn't mean you're being liened. It's just a legal requirement. So we'd actually prep them and say, okay, we're bringing on a plumber electrician. You're going to get a pre-lien. Here's what it is. Because otherwise they'd call us freaking out. How come you're not paying the plumber? What's going on? So
yeah. Thank you for sharing that. Absolutely. And always communicate what with your customers what to expect, that the preliminary notice has to be sent out. It's a legal requirement. It means nothing. I mean, unless you don't pay your subcontractors, and that's a whole different issue.
Exactly. Another question real quick. Can I file the notice of intent to lien to the insurance adjuster?
Yeah. Yes, absolutely. You can send it to the insurance adjuster, but who better to help you get paid if the insurance is not paying you than your customer? Your customer is a policy holder. Your customer is a person that you are there to actually help and restore their property. So why not have them on your side and be like, oh, Darren, homeowner, like I'm doing all, we finished the work. You're happy with us. You signed off on the certificate of satisfaction. Your adjuster is just MIA. Can you help us get paid? Otherwise, I have to lien this house. This is my notice. I'm going to send it to you. I'm going to send it to the adjuster too, but I need your help. Absolutely, the adjuster should get it. And once you do file that lien, email a copy to the adjuster, because a lot of times, if they haven't issued a check, they will add you as an additional payee on the check. They won't always do it. Yeah, they won't always do it, but once they do, is very beneficial to you.
Not to get too far in the weeds, but just another thought when you said that is we always try and go to the adjuster and say, hey, we need some help. What's going on? Something else I was encouraged my homeowners to do and my business owners when I had an issue was go to your agent. The adjuster's job is to settle the claim and move on. Your agent wants that commission next year. They should be your advocate on this whole thing. Get them involved and make them know what's going on and pursue your best interest. Absolutely.
Absolutely. That's a really good approach as well. Okay. So, lien waivers, you guys should always get a lien waiver if you're using a subcontractor. This is what will protect you in the example that Darren said, that the subcontractor is going to come and say, I didn't get paid, but you actually paid them. Have that lien waiver. So every time you pay somebody, we got two types of lien waivers: is conditional and unconditional. Conditional means that you're going to give them $1,000, and the lien waiver is conditioned upon the receipt of the $1,000 and the check clearing, right? So once that happens, the the waiver becomes unconditional, but it's an understanding that you're going to give me this much, condition on it clearing and me actually receiving the money. Unconditional lien waiver, it means that you actually received the money, or your subcontractor actually received the money, and they no longer have an interest in that amount of that they received for respect to filing a lien. So that $1,000, they cannot file a lien for that $1,000. So those are really important to have, especially for some insurance carriers. They want you to have it for project files, for lawsuits, documentation. All of this is important. And if a subcontractor ever wants to bring a claim against you for non-payment, these lien waivers of conditional, unconditional is really going to help you. So this is not filed on the title change. This is an internal document as well, and it should be part of your practice, just so you yourself, every time you get paid by the insurance carrier, right, even though it's on behalf of the homeowner, you can do the same. You can write a conditional that I'm going to receive $10,000. Here's a conditional lien waiver. So you're just communicating with the homeowner that, hey, I'm getting paid. I'm going to release my lien rights to this extent. There's nothing wrong with that. You're not giving anything up, but definitely practice it with your subcontractors if you are going to utilize them.
Couple more questions coming in, Yasmin. Yeah. You ready for it? So if the property or dwelling is worth less than the money of the amount of work done, is it worth filing a lien?
It's, it all depends. So let me tell you about my cost. So to file a lien with me through Need to Lien is $329, and that will cover all the expenses, because the lien has to get served on the property owner. So in Pennsylvania, I actually have to hire a sheriff at minimum of $70 to go serve that lien. In Michigan, it's certified mail via return receipt, so that's much cheaper. But the $329 is going to cover the property record search, so that I put the right owner on it, the filings, the service of the lien, and the filing fee with the court or the register of deeds, wherever it may be. So if $329 or whatever amount you want to utilize, attorney or another service, right? If it makes sense to you, then go ahead and do it, right? Because you never know what's going to happen. On the smaller files, like let's say something 2,500 and under, you're not going to hire an attorney, and you're not going to hire a collection agency. It's not going to be worth it. So why not just have a lien out there if it makes sense, right? Some states allow you to go to small claims depending on where you are. But it's a business analysis. I wouldn't just do it on every single job, depending on the size of it, but I would utilize it if you think that house has a potential to get sold. If that answers your question, let me know. I can clarify further.
To follow up on that just a little bit on my own. Yeah. So if they did a massive repair on a fire job or whatever, and they're owed $350,000 and the house is worth $300,000, they could still get a portion of it. They may not get it. It's better than nothing, right? I mean, you're still going to get what's available if you can get it. Okay. Great. All right. Normally the adjuster will not tell me whether they're going to pay or not for months. After I get their answers, it can be too late for me to file the lien. Would that matter? So what's some direction on the common problem?
So this goes back to my collection process. What is your collection process, right? So if your adjuster is not going to pay you, you have to communicate that with your customer. Your true customer is always the property owner, not the adjuster. The property owner is who deserves all the communication and transparency. So we know adjusters, some of them are just so busy, or some of them just, they fall behind. It is what it is. And you're not going to pay within your lien deadline. Keep your lien deadline. I don't know if you can put it in a software or however you want to keep track of your lien deadline for each project. But if you are within 10 days of your deadline, give yourself a minimum 10 days. Go ahead and file that lien and put the customer on notice as well. And you tell the customer, the only reason I am doing this is to secure my debt, because your adjuster is not paying. So don't wait on the adjuster, because and again, be mindful of your customer and the adjuster. If this adjuster is giving you millions of dollars a year, don't play this. Don't file a lien on every job, but file it on a job that is worth risking that relationship, whatever that may be. So you got to always be mindful of your customer relationship and your business development and practices. But just because the adjuster is going to take longer than the deadline you have to file a lien, don't allow that to stop to file a lien if you think you should file that lien. Go ahead and file it, but at least give yourself 10 days because the person, yourself or whoever has to file the lien, has to file it. And once I file it, it's out of my control because it goes in the registry of deeds and they have their own timelines and vacations and holidays, right? So it's out of my control. That's why I say give yourself 10 days to submit the lien to get it in time by the deadline.
And then one more question. If foreclosure is required, can you go after additional attorney's fees, court cost, interest for the fee, late fee, etc.?
So it all depends on the foreclosure statute in your state, right? So this is all state specific. I can speak to Michigan. In Michigan, we follow the American rule. The American rule says that to recover attorney fees, either the statute has to allow you to do it, or it needs to be part of your written contract, right? So for me, knock on wood, I've been successful in recovering attorney fees. I don't always get 100% of it by the judge. I get majority of it. But basically depends on your state and what your contract states in there. But definitely if your contract doesn't have attorney fees or interest in there or recovery of costs, go ahead and add it, because once you file the construction lien, technically you could recoup your funds, right? The expense of, for me, 329, for example. Be like, hey, homeowner, like, listen, it's $1,000 that I had to lien. It cost me another 329, we're at 1,329. You got to pay me. The contract here says you're responsible for fees and collection costs. So you can always use an avenue to recoup the amount that you use to the cost of collection. One of them is being a lien. You can use that as part of your negotiations. But in court, in this question, it's state specific, but in Michigan, I can do it. I can recover attorney fees. Now, would the judge want me to do it or allow me to do it? I don't know. But again, don't count on that. Never count on the ability to recover attorney fees to go ahead and foreclose or bring a lawsuit, because you're going to spend so much more energy, stress, anxiety, waste of resources and time dealing with lawsuits. That's not going to be worth it. It really is not going to be. And I'm an attorney and this is how I make my living. And I'm telling you, it's not worth it, because do everything you can to be proactive and have an effective collection process. So do not ever count on the ability to collect attorney fees to be like, oh yeah, I don't care, I'm going to go guns in and guns blazing to collect on this money. It's not the best approach you can have, but you could recover it.
Thank you.
Yeah. Touched on that. Okay, so just a few examples on lien deadlines. So California, 90 days from project completion or 60 days if notice of completion was filed. So in California, notice of completion is this other document that you filed that says Darren's restoration was on this job, he completed the work and the work is done. Notice of completion. That's what that means. In Florida, 90 days. Michigan is also 90 days. Illinois is 120 days. Texas wants to be very complicated. They're the 15th day of the 4th month from last date of furnishing labor or materials for commercial, and for residential, it is 15th day of the 3rd month from last month of furnishing labor and materials. Don't ask me why it's so complicated, but it is. That's Texas for you. So they're all different. They're all very different. You have to keep that in mind for your state. I was going to share this on my last slide, but in case I forget, I do have a 50-state survey document that I will provide to Darren and he can email to all the participants. And basically it allows you to just quickly look up your state, and the lien deadline is a resource, and feel free to look at it, use it, or just don't. It's fine. But it's a resource that I like for you guys to have should you want to make it easy on you to know your lien deadlines.
Couple more questions coming in.
Yeah.
Can I still file a lien if the contract is terminated because of job quality dispute, or can I still file a lien after the contract is complete, but there's a dispute of the job quality or issues?
So you can file a lien, even if there is a dispute. You just be mindful of how much you're going to file a lien for. So don't, you want to file the lien, is a lien document. Now, will your lien be valid is a whole different question. There's a different aspect. And in this case, let's say you file a lien for $500,000, and then there's some disputes, you go back and forth and you settle it out. But just file the lien for the true number that you think you are owed, right? If the contract says $500,000, that's your lien amount, or minus whatever you've been paid. Or if there's change orders, then go ahead and add the change orders to your contract amount, but make sure your change orders are in writing and signed off by the customer. But yeah, if you're terminated early, or if there are any disputes, none of them are going to give up your lien rights. You can still file a lien.
And just my own question, is that an adjustable thing? In other words, if I file a lien for $500,000 and it comes out that with the disputes and the issues that everybody says, okay, we really owe you $400,000, because I filed for 500, does that hurt me? Or is it okay, say, yeah, you filed for 5, you're only getting 4. If you're off on that number, does that have an impact on what happens?
Well, if you settle it at 4, then you just dismiss the lien that you filed for $500,000, right? So what happens if there is a discrepancy in your lien amount and what you're being challenged? Then it becomes a legal question, and the judge will have to decide if that is a valid lien or not. And that is, again, goes on to the construction lien statute of your state. So, for example, I had a case in Michigan. I filed a lien, but my lien amount was less than what the contract amount was. So it was fine, even though we were in lawsuit disagreeing over the amount owed and the workmanship, my lien remained valid. But if you are going to lien for $500,000, your estimate is $100,000, and you say the difference of 400 is change orders, but you have nothing in writing, you're going to have a hard time there.
Gotcha. Okay.
Yeah.
The question, I was informed you have to file a preliminary lien within 20 days of the first day on the job in California. I don't know if you have all the states in mind right now, but.
So preliminary notice, yeah. So some, like I said previously, some states require you to do it regardless of your position of a general contractor or subcontractor within 20 days or 15 days, whatever it may be. But if that's what you're informed, you can do a quick Google search to confirm that. But I just can't really confirm that right now, and I apologize.
All right. You don't know all 50 states exact rules? Come on, yeah. And another question. We work in Florida. Does the 90 days start from the date of completion of physical work, or when we finish writing the estimate and building the claim to be submitted?
Perfect intro to my slide right now. So the last date of work is the last date that your crew was there, that they did the work and they walked off and the work was completed. So the best practice to consider what the last date of work is to do not consider warranty work, corrective work, punch list items. Don't consider them as part of your last date of work. So if your last date of work was 90 days ago and I call you to fix a plumbing issue, that's not going to restart your lien clock. Don't use that as your own advantage. Some states are different, but the best practice is do not account for corrective punch list items as part of to add on to your lien deadline. Don't do that. You're going to get yourself in trouble. And unless you have a valid change order, that's different. You're extending your scope of work, you're extending your timeline, and then you can use that to establish your deadline of filing a lien. But don't use corrective work and punch lists as that deadline. Last date is when you truly was there and you finished your work.
So going back to the question we had a few moments ago, that's when you finish the work or you're finished with that portion of work. In other words, if you're done because there's a dispute, we're not bringing you back, whatever, that's the same day. That's the same time frame, whether you're done with the job or whether you've reached a point where you can't keep going with the job because of whatever reason.
Exactly. Thank you for clarifying that. Yeah.
But that's a huge myth. I hear that all the time. If I could just get back on that job site and sweep up some debris in the garage, that starts the clock. I've heard that so many times. So
yeah, no,
thanks
don't
for
do that.
clarifying that.
And the reason I urge to have this best practice when you are dealing with consumers, so residential homes. We are in such a litigious society, and we have like the California, the gentleman or female in California. I don't know who they are, sorry, but you are very consumer friendly, very consumer friendly. So should you gonna work around and try to be cute with the lien deadline, and you do that, you're gonna open yourself with a whole lot of potential lawsuits with respect to consumer protection. Yeah. So that's why I say be on the best practice, be on more on the conservative side with these, because you don't want to open yourself with that counter lawsuit. You are going to get if you're going to do a foreclosure claim, you're going to get countersued automatically. Any attorney with two brains is going to countersue you. So just keep that in mind. Don't play around with the deadlines. So again, if you are a subcontractor, always submit your notice of furnishing and preliminary notice. Make it as part of your business practice. All of your project managers should have this. It's a form, it's simple. Just send it in. Use the software, use whatever you want. It's really just send those in. I call it the lien clock. Just figure what that is. Like Michigan, 90 days, Florida, 90 days, Illinois, 120 days. Texas is funny, so have fun with that one. But like, know what that is. Everyone in your team should know what your lien deadline is. Is one date from the last date of work. It's not that hard to remain, because different people within your company are looking at your projects, and someone would be like, oh no, these jobs are coming up, right? We need to file a lien, just for someone to know that, just to keep the team more engaged, to protect you and secure your money that you guys all put out. And honestly, you all finance all these jobs yourself. You're not getting paid in advance. You have to wait to get paid. So what entails, what information needs to go into a construction lien document is a lot. So make sure that you provide the correct information. So the first thing is your information, your entity name and your address, basically who you are, the property owner, and the name of the person hiring you. And this goes back to the distinction. Just because the contract party is Darren does not mean that he owns the property. So you got to make sure that you know the distinction of the two when you run a title chain report, or you check however you want to check that, to make sure that you're listing the correct property owner on it. Location of the work performed, right? Property managers, they're sitting in their corporate office, but they're going to send you, town next door or whatever it is. The work performed is going to be different than the address of where the property management is sitting. So make sure you list that properly. First and last date of work. So a lot of states, I would say almost all of them, that last date of work needs to be part of your lien document, because that's the attorney for the homeowner who's going to see it is going to do the math. And that's where you're going to run into issues with respect to playing around with the clock that you had, your lien clock. Legal description of the property. So basically that very long legal description, you've got to pull up some sort of mortgage or warranty deed or something for you to get this information, tax report. I don't know however you guys want to obtain that, you go ahead and you do that. But the legal description is that legal description of the property. Self-explanatory. Description of the services or materials provided. This is not a very long list, but you need to give a general description of what it is that you provided that you didn't get paid for. The amount of the contract, the amount paid, and the amount owed needs to be listed. And in some states like California, legal notice, there's a statutory legal notice language that needs to be part of your lien. Some states have it, some don't, but that's just a legal requirement. So you got to be familiar with that. If you're doing this yourself, is daunting. I understand, is a lot of work. But if you use a local attorney, use whoever, they should have all of this information with respect to your state. So all you do is you give them the necessary information, and everything else is done correctly for you.
Couple questions on this topic.
Yeah.
Using collection agency versus filing lien, which way should I go?
Oh, well, I don't think it's either or. I think it's both. So what the lien does, the lien, it gives you leverage, so much leverage. You are owning, you have a secured interest against the property that will allow you to foreclose. That's serious leverage you have. So if anybody tells you don't file a lien, I'm very skeptical of that, because to me, I'm mixing all my slides up, so I apologize. But based on my report, I filed over 200 liens this year, and over 40% of them so far have been discharged. So that to me means they've been paid and settled out from all these clients that I have. So it's a high percentage of liens that get discharged based on that dialogue opening up. They receive this notice of lien. The homeowner is like, oh, shoot, what is this? Let me call Darren Restoration and figure what this is, because I don't want them to foreclose on my property. It's a real serious threat. No one wants to lose their home, especially commercial owners. They don't want to lose their property. So I say definitely file the lien and then use your attorney or collection agency.
And some of that, like you're saying, circumstantial. If somebody owes you $2,000, probably not worth filing a lien, go to collections.
Yeah,
so
exactly.
All right, perfect. Thank you. And also the next question is, can you clarify the first day of work, when we actually swing hammers or the initial walkthrough with the project manager?
So you can define it as when you first delivered materials to the job site, or when you started working. It could also be the first date of the contract, right? You signed a contract and then you went back to your office. You started to put together your team. You started ordering materials. So that really is a first date of work. It doesn't really have to be the physical aspect of construction, but it could be the administrative aspect of it as well. So you walk the project, you have a contract signed, and technically when you have a contract signed with the property owner, you're starting the job. You're going to go back and deal with the operations aspect of it. So I would say when your contract is signed, or a lot of times you should have a contract. So when your contract is signed, your job starts.
It sounds like there's almost a little bit of leeway in that. I mean, could they come back and say, well, that's not really when you started. You guys didn't even show up until the 13th, even though we signed the contract 2 weeks before that?
Well, it doesn't affect your lien rights though, right? Your lien rights are affected from your last date of work, not your first date of work.
So that's just sorry, go ahead.
Go ahead.
So that's just an indication of when we started, but it doesn't really have anything to do with what you're. Okay, that's a great
answer. So I'll clarify where the first date of work is going to run into is when you sign a contract today on a fire job, which we got the fire department throwing water down. So you signed a contract today, you don't start for 2 weeks. Now you have mold issues. You're going to get sued that you are the cause of that mold issues because you waited 2 weeks to come to my job site. So that's that first date of work is going to come into play, is your delays in the project from when you said you're going to start and when you actually started.
So quality workmanship issues, nothing with the lien.
No, that goes back into workmanship issues and punch list items and warranty work.
Perfect. Thank you.
Mm-hmm. Okay, so let me see. Maybe I want to skip. So contract language, let me talk about that. Almost all states have some sort of a contract language or statutory language that has to be part of your contract. So in Michigan, it's just a little blurb that you copy paste into your contract that says, based on this law, I am, as a contractor, as an electrician, as a plumber, I am entitled to file a lien should you not pay me, customer, right? Something like that. Almost all states, especially the consumer-friendly states, have such notice requirement, and that needs to be part of your contract. Because a savvy attorney is going to be like, Darren, you don't have this notice in your contract. Your lien is invalid. That's the argument you're going to run into. Residential work plus a written contract equals a lien. In Michigan, you have to have a contract for residential work. Commercials, apparently we don't care for a contract, but residential, we do. So to have a valid lien means that you need to have a contract, a written contract. And I'm pretty sure all the states, almost all, will require this requirement.
that kind of answers the question that came in while you move to the next slide about whether a lien, and you can clarify this for me. It's what I'm hearing is it's not whether you do collections or whether you do a lien. You do collections, and a lien might, an attorney letter might be part of that, a nasty letter from your office manager, or a lien. So the collection is getting your money. A lien is one of the tools that might happen within the collection process. So it's not really,
Absolutely.
yeah.
Absolutely. Because if you're having issue collecting on a file, then go ahead and lien it if it makes sense to you financially. You know, if a $2,000 job, you know, 329 is a good chunk of that money. But if you have your jobs are worth it, lien should be part of that package documentation that you send off to your collection agency or to your attorney. And if your attorney or collection agency is good, they want you to have a lien. So if they're telling you otherwise, I mean, I don't know who anybody's using, but if there's an attorney or a collection agency that's telling you, oh, don't file a lien, we don't need it, be very skeptical of that, because that doesn't make sense to me. That gives me so much power to collect on your money. So we touched base on all these slides, so I apologize if I'm repeating myself, but basically the lien will allow you to secure your debt against a real property, private or commercial, not public. Public is a different avenue. Insurance carrier may add you as an additional payee on the insurance checks. And these are beautiful when you got a mortgage involved. Mortgage companies take a lot of time. And when you just have a bad customer who probably is going to take your money. So you want that. It prevents the sale of the property because the title company will have to, or, you know, someone has to pay you off. And I've dealt with this a lot. I've filed liens and customer forgets about it, client forgets about it, and then I get a call from an agent or a broker like, oh, we have this lien, where do I send the check? I'm like, oh, beautiful, here. And then they send you a check and they tell you how much. Well, it'll be like, oh, it's a $5,000 lien plus this much fee because for the lien and attorney fees or whatever, and they'll send you a check. No one is going to start nickel and diming you when they want to sell their property. They will pay you off. Refinancing. So interest rates were high, they're coming down, they may come down again. You're going to get paid on those liens, even if they just sit there because they want to refinance it and they have to get rid of the lien in order to get refinanced. And foreclosure is their last resort, and it's a powerful ability to have.
Can I clarify just one thing real quick? So it prevents the sale until the debt is paid. You had a previous slide that I think said you have 1 year to foreclose. So after a year, you can't foreclose, but the lien still remains on the property in case they try and sell it, or how does that tie together?
Okay. So good question. I will clarify that. So let's use Michigan, for example. So we have 90 days to file the lien. We have 1 year. So today is August 16th, right? Am I right? Yeah.
They keep changing it. Yeah.
So I file a lien today, and by filed is not when you submit it, it's when the registry of deeds or the court sends you a stamped copy back. So let's say I received mine from the registry of deeds. It says August 16th, 2024. I have a lien. I have to serve the property owner. So I do all of that. I have until August 15th, 2025 to do something with this lien. Either I foreclose on it or I settle it out. But if nothing happens after August 15th, 2025, I really don't have any legal perspective on this, legal authority over the lien. The lien becomes automatically void, if you may say so. Like, it's just void. You cannot enforce on it. You can't. But there have been some cases that the lien has been out there and I got paid on it through a broker. You know, they're not going to fight me over it, but it's just, you can't really do anything if you don't enforce it within the time period you're given.
So if you don't do that, and I can't remember the term, the lien release, you know, if they pay, you release the lien. If they don't pay, you don't release it, so it's still there. But if they wanted to fight you, they could, but they'll probably just pay you off to be done with it.
Yeah.
Perfect. Thank you.
Sure. So this is why I say, like, having a lien is important. Like, this is just a little bit of data. So if you don't collect within 90 days, right? So your last date of work and 90 days from there, your liens, your average collection is going to recovery period is going to decline by 80%, right? And it's going to go significantly down from there. Collection agencies cost is 25 to 45%. Attorney fees are 250 plus. California, guys, you're paying over $500 for attorneys. So, like, if you have a lien and you can use that and use it as a leverage to collect on the funds prior to this 90 days, it's going to really help you, and it's going to help your collection agency and attorneys to collect your money even faster. It's very, very important. And I truly, honestly, like, believe that the construction lien is the best tool you guys have. It's the best leverage you guys have. It's very important because it goes against the property, the livelihood, the asset, the money making for commercial, right? They have tenants, they have whatever, they have revenue coming in from the property. So just keep that in mind. Your collections declines, and a dollar yesterday is not a dollar today. It's not worth the same. So your value is also decreasing. So I touched base, but in 2024, over 40% so far, and I'm only in August, they've been have been discharged. So they've been gone. They didn't involve me. I didn't have to send any nasty letters. I didn't have to communicate. The customers just handled it themselves. Commercial customers are the best. They pay off. Residentials, they're more difficult, but they will eventually pay as well. They're just a little more harder to get to receive payment from if things go south. And then I touch base on my 50-state survey. I will share that with Darren and his team, and they can mail it out to all of you so you have that information.
I've got a question that came in that kind of touches on what we were talking about a few moments ago.
Yeah.
I've heard that if we file a lien and the customer is not selling the property, the lien only stays 2 years and it cancels without forcing them to pay. Is that true?
It depends on where you are, right? That probably is whatever state you are, you got 2 years to enforce your lien. In Michigan, I have 1 year. So
Illinois.
No, yeah. So
okay.
State specific, yeah.
State specific, perfect. Thank you.
Yeah. Wow, I finished on time, and I have about 7 minutes for any questions. This is my contact information. I will make myself available. I will answer any questions. I will help you if you want to understand how to make liens into your collection process, notice of liens, or whatever it may be. And I love to share my industry knowledge within a legal perspective. So should you guys ever have a question, let me know, and I will help you as much as I can, or refer you to someone who I can trust to help you out as well. But I'm just a resource, and I'm happy to help whenever you guys need that. With that, I will bring in your questions. I appreciate all the questions you had, but let's answer them all.
Had some great questions.
Yeah.
Anybody else that wants to throw them in there? Question, can we get the recorded presentation? And the answer to that is yes, we will have that available. Takes a little bit of time to render it and get it up, but we will have that available. Not a question, but it's something we all echo. Thank you for this wonderful and helpful info.
Of course.
Anything else from anybody? Our customer deposited a 2-party check made payable to our company and the insured. She spent the money and can't pay her bill. No, that never ever happens. Any feedback or help on this?
Okay, so I don't know where you are in your process. So if you haven't liened, go ahead and lien it. Also remember that because they don't have your endorsement on that check, 2-party, 3-party check, your attorney may have a claim for fraud against the individual. So that's important if you hire an attorney, that's fraud, because we all know you cannot deposit a multi-party check without the proper endorsement. So that opens the door for bringing a fraud claim, and is a powerful claim to have.
Side note, I still remember going to see a client who owed me $7,500. And I said, I just talked to the insurance company. They said, you've got the check. And she said, oh my gosh, well, it was so great. I was 2 months behind on my house, 3 months behind on my car payment, and now I'm out of debt. I said, well, not totally out of debt. You owe me $7,500. So,
yeah.
Can it create a problem if I send a preliminary notice to a California customer and it's more than 20 days since the work was started?
Do it. It's better to be on the safe side. Go ahead and send your preliminary notice, because in California, where they have stricter rules, if you are a subcontractor or a general contractor, you got to clarify if you are even mandated to send that in. Should you want to foreclose on that lien, the first thing the other attorney is going to be like, give me a copy of your preliminary notice. So go ahead
So
and send it.
if you do it wrong, they can possibly invalidate it. If you don't do it at all, there's nothing to invalidate, right?
So
If you don't do it, you
it,
definitely don't have the
yeah,
rights.
it's not really invalidating your lien. It could reduce your lien amount, right?
Oh, interesting.
What
Okay.
so what can happen? You have a lien for $100,000, but you forget to send in the preliminary notice. So you send in the preliminary notice 3 months later. Whatever work you did within that 3 months without the preliminary notice being sent out can get deducted from your lien amount. So it will reduce it. It's all very tricky. It's very, very state specific, but that's something that can happen. And some states will totally invalidate your lien. So
But
just
there's still
send
some
those
value.
out.
Yeah. Wow.
There is
So
value, yeah.
that's great. I didn't realize that. I thought it was kind of an all or nothing. That's good information. So thank you for the info. A comment, it still creates an urgency in the customer's mind. Great points. So
Yeah,
all
absolutely.
right. Any other questions from anyone? Great questions, great input. Thank you. We work really hard at learnedrestore.com to provide quality training in the industry. That's why we reached out to Yasmin. She's been such a good advocate for our industry, and really appreciate her coming on. It's been nice for me when our clients in Michigan need legal help. It's easy. Here's who you talk to, knows her stuff. She'll take good care of you. I'm really grateful though and excited that she now has, not just for people in Michigan, but this nationwide resource of needtolien.com that can assist everybody in a very reasonable way. It makes this complex, important tool of liens something that's much more accessible to every contractor. So thanks for, I know it had to take a lot of time and energy to put that together for 50 states, but we're glad to have that. So thank you so much for everybody who joined. Thank you so much, Yasmin, and everybody have a great day and go restore something.